How do you protect your assets against Medicaid's look back? Hi, I'm Lynn St. Louis, estate planning and elder law attorney. At Elder Law Group, we are experts in Medicaid planning. This is an area of practice that very few attorneys practice in, but it's something that we do because we really care about our clients and we want to make sure that everything they've worked so hard for isn't spent down on their long-term care costs or isn't subject to the state's estate recovery. I have a lot of experience with this. I helped my parents over 14 years of long-term care, so it really matters. It really matters to all of us here at Elder Law Group. Let's start with some basics. What pays for long-term care? Does Medicare? No. Only Medicaid will pay for your long-term care costs. So that's something that comes as an unpleasant surprise to a lot of people. All right, so Medicaid pays for long-term care. How does that work? Well, it truly is set up as an impoverishment program, at least if you are single. So if you are a single person, the state says you can have $2,000 in countable assets, and that's it. Now, not everything is countable. Your house doesn't count, but if you keep your house and you're single and you go on Medicaid, guess who will get your house? Not your kids, it will be the state will get your house when you're gone. So there is a lot that goes into Medicaid planning to make sure that the state doesn't get your house. If you are part of a couple, the state allows you to keep more than $2,000. In the state of Washington, it's between $60,000 and $135,000, and it depends on what the level of care is and what your assets were when the first spouse needed care. Is this something you can do on your own, Medicaid planning? I have to tell you, this is absolutely impossible for anybody to do on their own. And if you're looking for an attorney, please look for an attorney that does Medicaid planning. So who does Medicaid planning? Well, elder law attorneys do, but not all elder law attorneys do. This is really a specialty within a specialty. So if you're looking to hire an attorney, ask them questions. How many Medicaid applications have you done? How many do you currently have pending? Do you do strategies for crisis planning? You should be satisfied with all of these answers. Do not go to somebody that doesn't have a lot of experience in this area. Medicaid has a 5-year look back. What does that mean? It means that if you give away assets within 5 years of applying for Medicaid, Medicaid says, well, you don't get any benefits, you just gave away assets within the last 5 years. So if you're giving away your money, you don't need Medicaid benefits. So be very careful. Do not give away your assets within 5 years of applying for Medicaid. A lot of people do this though. They say, oh, well, I'm gonna need care. Let me give my house to my child, or let me give my bank account to somebody. Don't do that because you will not be eligible for care even though you've given away all of your money. What do you do instead? See an elder law attorney with expertise in Medicaid. If you have given away assets within 5 years and you need to apply for Medicaid, we can help you make sure that you get benefits and still preserve assets. There are a lot of strategies that exist and they're very unique to your own situation. So if you have given away a house, well, first of all, we say, please don't give away your house. Don't do that. Don't give away anything unless an attorney experienced in Medicaid has put in writing with a plan that you've seen and you understand, here, this is how we're going to preserve your assets. We are going to give away your house. We are going to give away your money. Then we're going to file for Medicaid. And then Medicaid will impose something called a period of ineligibility. And there'll be a plan for how do you get through that penalty period of ineligibility. How do you pay for that when you have no money? You see, this is like, well, how would you possibly do that? It has to be part of a plan and something that is put in writing that you can understand. There are programs in Washington that have no penalty. Community First Choice, CFC program, you can give away assets and there's no penalty. If you are in skilled nursing and you're under the age of 65 and you haven't had Medicare, then there is no resource limit. If you have a child who is disabled, you can give away all your assets to the disabled child. If you have a caregiver child who's cared for you for 2 years in your house, you can give your house away to the child, but you have to do it without any private pay period between the time you give it away and you go on Medicaid. There are so many exceptions to the rules of Medicaid, and I have to tell you, they pretty much make no sense. At least they don't make common sense. And that is why people don't understand them. They are not drafted so that they are clear and understandable. So it is a very complex, a really confusing area of law. And a lot of times people see that and they just give up. It's like, I just have to spend down everything until I have nothing, and then the state will pay for your care. That's what most people do. Please don't let that be you. Seek out an elder law attorney who has expertise in Medicaid, and will say that. I have expertise in Medicaid. I understand the rules. I understand what is the best plan for you. That way, you at least understand what your options are, and everything that you've worked for and acquired during your lifetime, there may be a very good plan, a very good way to keep those assets. So don't proceed with spending down everything unless you know that that's the only choice, which frankly, rarely is that the only choice. Almost always we can prepare a very good Medicaid asset preservation strategy so that you can make sure that everything you worked so hard for can be preserved, and yet you will qualify for Medicaid benefits.